Hi, I'm Byron Williams. I'm Director of the Public Interest Law Center, or PILC. PILC is an office of dedicated legal professionals, and we work with the law to advance economic and social equality. Our clients are individuals or groups who want to make changes in the areas of environmental law, human rights, consumer rights, access to justice, and the revitalization and assertion of Indigenous legal orders. Our team has helped put together this webinar series because public engagement with legal processes is a cornerstone of democracy. The ongoing climate change crisis and our shared responsibility towards reconciliation makes this engagement particularly relevant in the area of environmental law. We've invited guest speakers to share their knowledge and to improve public understanding how each of us can do our little bit more to engage in the decision-making process that impacts us all. We're so grateful that you've joined this discussion, and we look forward to hearing your feedback. Thank you.
My name's Glenn Korolick. I'm the Executive Director of the Manitoba Eco Network, and we're one of the sponsors of the Navigating the Law series, along with the Public Interest Law Center. For those who don't know anything about the Manitoba Eco Network, we're a nonprofit, charitable environmental organization. We've been around for about 35 years. The organization is doing some great stuff these days with all the volunteers and our new board of directors, and a good example is this webinar series, which we hope you'll enjoy. If you have any feedback after the session, please provide it to us, and we're always looking to make improvements. Once again, thank you for attending, and I hope you have an enjoyable webinar, and we'll talk to you again.
Hi, welcome to the third installment of Navigating the Law to Protect the Environment. My name is Byron Williams. I'm hosting today's event, and I hope everyone is safe in these very stressful code red times. As we begin, it's important to acknowledge that while many of you are viewing us from all over Turtle Island, the organizing team behind this project are working from Treaty 1 territory on lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and in the heartland of the Métis people. We are honored and grateful to be here. We'd like to thank the Manitoba Law Foundation, who are providing financial support for this series, as well as the University of Winnipeg, who are saving our lives with outstanding financial and technical support. Thank you also to National Captioning Canada. They're helping us to provide closed captioning for these events. And to my personal hero, Evan, from the University of Winnipeg Tech Support. This webinar is titled, Are Class Actions the Way to Go? A class action lawsuit is a tool that can be used to address power imbalances between individuals and large entities like the state and corporations. Our guest speakers are Professor Yasminka Kalijic and Katrin Gauthier, and they are eminently qualified to speak about the promise that class actions hold for addressing climate change. I'm really thrilled to be able to introduce them. Katrin Gauthier is the Executive Director of Environ Jeunesse, a Quebec environmental organization that is focused on educating youth to take action on environmental issues. Katrin holds a master's in international law and politics. She specializes in international climate negotiations, environmental issues, education, and human rights. In 2018, Katrin and Angers launched Canada's first climate change-related class action lawsuit against the federal government. This lawsuit is presently moving between our courts, moving through our courts. Professor Kalajic is an associate professor at Windsor Law, and she's widely published on the subject of class actions. She has an upcoming publication pending on environmental related class actions in Canada. She speaks regularly about class actions at scholarly and judicial conferences in Canada, the United States, and Europe. And she is the founder and director of the Class Action Clinic, the first clinic in the world to focus on the needs and interests of class members. And just speaking personally, I've already found that website a very useful location. Our two guests have prepared a thoughtful presentation for you. There'll also be a question and answer period in the last 20 minutes. So please do park your questions in the chat as the event goes on, and take it away, team, and thanks again for doing this.
Well, thank you very much, Byron, for that introduction, and very, very warm thanks for inviting me to participate in this event today. Catherine and I have prepared a PowerPoint, and I'm hoping that it'll show up on your screens and that I'll be able to advance the slides in a timely way. So our roadmap for today is that I will first introduce you to the elements of a class action. This is like Class Actions 101 for those of you who aren't familiar with this form of litigation. And then I'll turn to the question of climate change litigation specifically. So what do we mean by climate change litigation? And can climate change litigation take the form of a class action? And even if it can, should it? Catherine will then take over to give really, the first-hand account of Canada's first climate change class action, the Environnement Jeunesse case. And then we will each sort of talk about what we think to be the pros and the cons of using class action litigation to combat climate change. And that's before we take your questions. So first, let me give you the basics of a class action. The definition of a class action is that it's litigation brought by a representative plaintiff on behalf of many people who share the same causes of action against the defendants. So similarly situated people who, instead of bringing their own litigation, are proposed to be represented by a single or a handful of representative plaintiffs. It isn't joinder, right? It isn't a bunch of individual lawsuits that are joined together. It isn't a multi-plaintiff lawsuit where you have each person with the cause of action named in the statement of claim. Rather, you have a statement of claim initiated by a single or a couple of people, or in the case of Quebec, an association or organization that purports to act on behalf of a very large group of people. And the class action mechanism has been deemed by the Supreme Court of Canada as useful, a useful addition to our civil litigation procedure, because it is efficient, right? It is more efficient to have a single action on behalf of many than many individual actions. It's thought to increase the chance of behavior modification because you have the leverage of a large group of people bringing litigation against a defendant, whether the defendant is the corporation or the government. And it is principally about access to justice, that for reasons of economic barriers to litigation or psychological, informational barriers to litigation, a class action is thought to overcome some of those barriers because one person can bring litigation on behalf of many. So what's ordinary about a class action relative to individual cases? Well, it's a procedural statute. There's class proceedings legislation in every province of Canada with the exception of Prince Edward Island. And specifically, those statutes are procedural in nature. The courts have said over and over again that a class action does not confer rights. if you have certain rights, for example, standing to bring an individual lawsuit, then you have that standing in a class action. But if you don't have standing in an individual litigation, suing by way of class action doesn't give you standing. So it doesn't purport to change legal substantive rights. Jurisdiction and justiciability are principles that also don't change as between class actions and individual lawsuits. And this is something to remember as we listen to Catherine talk about the Jeunesse case. The other thing that's important to note is that the two-way costs rule that applies pretty much everywhere in Canada, the idea that the loser in a piece of litigation pays the winner some portion of their legal costs, that applies in class actions, but in only some provinces. So in Ontario, Alberta, Saskatchewan, Newfoundland, and Nova Scotia, adverse costs are a risk that litigants in individual and class action litigation have to bear. And you can imagine that in a big, complex class action, that's a pretty big risk when it comes to a plaintiff in a class action. But importantly, in Manitoba, among a couple of other provinces, cost shifting only applies prior to certification. And once a case is certified as a class action, and I'll explain in a second what that means, there is no adverse costs regime. And that can be quite an advantage to a plaintiff in a class action by comparison to ordinary litigation. So what's special about a class action? Well, there's a famous passage in a BC case where the judge said a class action, a proposed class action, because it's not a class action until it's certified by a judge, but a case initiated as a potential class action is no ordinary action, it's one with ambition. The ambition is that it will become a class action once it's certified by the court as such. And so there's an important step in a class action that doesn't happen in individual litigation, and that's the certification hearing. At the hearing, the representative plaintiff has to satisfy the judge that the claims of the class are appropriate to prosecute on a collective basis. There must be a commonality of claims between the class members, an absence of conflicts of interest between the class members, as well as a suitable representative plaintiff with competent counsel. There must be proof on a pretty low standard, but that it is a preferable procedure, that a class action is the way to go as opposed to, for example, a test case or some other alternative. What else is special about a class action is that the statutes confer jurisdiction on the judge to award aggregate damages. That is, a judge can assess damages in the aggregate once liability has been determined. And this can be quite an advantage over individual lawsuits where each individual person has to prove their own damages. And finally, I raise this because it becomes important in the Jeunesse case. In class actions, there's the peculiar ability of a judge to award damages not to the plaintiffs, but rather to a nonprofit organization, a charity, some other third party, where it is impractical or impossible to identify and compensate class members directly. And so this is pretty unusual. It doesn't happen in ordinary litigation. In ordinary litigation, you know who the plaintiffs are, you can identify them, you can pay them their compensation. But in a class action where the class may be hundreds of thousands of people, it may be just too expensive or difficult to identify all of them. And so instead, the court will say the damages or the settlement money should be paid to a third-party nonprofit who will use the money for things that will provide an indirect benefit to the class. That then takes us to the question of whether climate change can be litigated. So we do know that class actions have taken place in environmental justice, generally speaking. So questions of contamination or pollution have been brought by way of class actions, and normally they're pleaded in tort, nuisance, for example, or on the basis of a breach of some environmental statute or regulation. But climate change litigation has undergone a bit of a change from that normal model of litigation. The definition of climate change is what you see on your screen. It's strategic litigation before either domestic courts or international tribunals, all involving the use of various legal doctrines in order to compel the reduction of greenhouse gas emissions. And so we had in the first wave of climate change litigation a couple of decades ago, using, again, torts or breach of statutes to try and achieve a reduction in greenhouse gas emissions. And those types of cases were largely unsuccessful. But then came a second wave of climate change litigation, which instead of using torts or environmental regulations as their basis, instead employed a rights framework. That is, beginning in the 2000s, I would say, the litigation looked to address climate change directly, but unmoored from any statutory obligation to protect the environment. These claims instead used a rights-based approach to compel governments to mitigate climate change or take steps to protect vulnerable communities facing its impacts. These strategies are necessary in light of the lack of codified or common law substantive rights to sustainable environment, as is the case in Canada. And much has been written on the human rights dimensions of climate change, and there is explicit acknowledgements of the links between climate change and human rights in various international documents, including the Paris Agreement. So climate change litigation of all types has proliferated across at least 25 countries, with the greatest number of cases being filed in the United States. There's the famous case of Juliana, which earlier this year finally received its death blow. It was dismissed by the Ninth Circuit as being non-justiciable. But a success story could be found in the Netherlands, where in the case called Urgenda, the Dutch court found that the national government owed a duty of care to limit carbon emissions and rejected the government's arguments that their ineffective action to reduce GHG emissions was non-justiciable, or that their contribution to global climate change was negligible. There was also a success story in Pakistan in a case called Lagani Lagari, a novel action brought against the Pakistani government, which alleged its inaction on climate change violated the constitutional rights, specifically the right to life, of Pakistani citizens. The Lahore High Court determined that the state's delay in implementing a framework for the implementation of climate change policy offended the fundamental rights of citizens. And then the court fashioned a novel remedy. The court first directed several government ministries to each nominate a climate change focal person to help ensure the implementation of the framework, and then to present a list of action points by a given date. The court then created a climate change commission composed of representatives of key ministries, NGOs, and technical experts to monitor the government's progress. In Canada, the rights framework takes place in the form of charter arguments, the rights to life and liberty in Section 7 and equality under Section 15. In Canada, there have been 3 climate change lawsuits. There's the class action in Quebec that Catherine is going to speak about, but there have been at least 2 other cases, not class actions, one brought by 2 houses of Wet'suwet'en Indigenous groups in British Columbia, and the La Rose case brought in the federal court on behalf of 15 youth over the failure of the federal government to adopt a climate recovery plan. Now, why is it that class actions might be used to promote climate change litigation? Well, the game changer was the Supreme Court of Canada's decision in a case called Ward. that had nothing to do with climate change, but it was the first time that the Supreme Court held that compensatory damages could be awarded pursuant to Section 24(1) of the Charter. So if a litigant is able to satisfy the court that there's been a violation of a charter right, for example, Section 7 or 15, one of the remedies that a court is entitled to order is monetary damages. And the court laid out a test for when there is a functional need for damages following a charter violation. And it's a four-part test where the court is concerned with showing that compensatory damages are needed to create a disincentive or to show, in fact, to punish the charter violator for their actions. But the court will also consider countervailing factors such as the availability of some other remedy to effectively address the charter breach, like a declaratory judgment, or concerns for good governance that might obviate against the order of damages. What's important for you to recognize is that Ward created a financial incentive for entrepreneurial class counsel to take on charter-based class actions. Prior to Ward, it was very difficult and quite rare for a case to be brought on the basis of a charter breach because of the general unavailability of damages. And class action lawyers who take on the risk of a class action are doing so on the basis of a contingency fee, meaning they only get paid if there's success in the litigation, and then they take some percentage of the damage award or the settlement amount to pay for their time. And so in order to take on the incredible risk of a large piece of litigation, especially one against the government of Canada, there has to be at least the possibility of monetary damages at the end of it in order to justify the lawyer's investment. Ward marked a turning point where it created a possibility of financial damages at the end of a charter breach case from which the lawyers could get paid. And so you see in some of these climate change class actions in Canada and elsewhere, seeking monetary damages, but specifically damages that could be used for climate change action. In addition, they seek declarations that Canada has a constitutional or common law obligation to act in a manner compatible with maintaining a stable climate. Orders are sought to prepare an accounting of GHG emissions. And as happened in the Lahore case in Pakistan, they seek an order to develop and implement a climate recovery plan. The big question in climate change litigation generally, as well as in climate change class actions, is this justiciable? Is the question of whether the court has a constitutional obligation to reduce GHGs something that a court of law, rather than parliamentarians, has capacity to consider? And we have one negative case, and that is La Rose, that federal court challenge, where not very long ago, just several weeks ago, the federal court handed down a decision that said, while the courts have institutional capacity, for example, to consider complex scientific evidence, they lacked the constitutional capacity, if you will, because climate change is primarily a political question. And this is the operative sentence from the judgment, that the diffuse nature of the claim that Canada had failed to meet its constitutional obligations to preserve life, especially among youth, to reduce carbon emissions, cannot be characterized in a way other than to suggest the plaintiffs are seeking the court to become involved in Canada's overall policy response to climate change. And policy is not justiciable. So that was a very unfortunate decision. My understanding is that the plaintiffs are appealing or seeking to appeal that decision. So in one case, we have the court saying climate change, not something that a court can consider. But as you will hear from Catherine, a Quebec court came to a different conclusion. So I'll turn it over to Catherine.
Thank you, Jasminka. I also want to thank you both, Byron and Max, for their kind invitation and also their real interest in our case. Also appreciated working with Jasminka in the preparation of this panel. So my hope this afternoon is to provide some practical insight about our class action, which is, as you said, really interesting, and also the first climate class action that has been launched on behalf of young people in Canada. And so maybe to start, let me first tell you about the very early beginning of the case. And so for more than 40 years now, the nonprofit organization where I work, which is called Environnement Jeunesse, has been acting to raise awareness among young people on environmental issues, but also to provide some tools for young people to get engaged in climate change issues. Environnement Jeunesse has also been speaking to several UN conferences on climate change, including the now famous Conference of the Parties of the UN Framework Convention on Climate Change. Maybe on a personal note, I have been involved with Environnement Jeunesse since I was in high school, when I was 14 or 15 years old, leading a composting project with the cafeteria. And then I got selected to be part of a youth delegation to the UN conference back in 2005. The conference was held in Montreal, and as I was the youngest youth delegate there, I was also lucky to be able to speak on behalf of our organization to 10,000 delegates. And then my activism continued in 2006, 2007, and so on, until I became, 4 years ago, the executive director of Environnement Jeunesse. And maybe more recently, in spring 2018, I first met Laure Varidel, that you can see on the picture. She's a very long time member of Environnement Jeunesse and also a well-known environmentalist here in Quebec. And she also happens to be the spouse of Bruce Johnston, who is one of the lawyers at the TJL law firm in Montreal. And for those who have no idea about this law firm, maybe to briefly summarize, they've been really active in environmental and social issues, and they have run several and significant class actions. So class action is really their specialty, if I can say that. And so maybe what led me to this specific case is, as you all know, climate change is real, and we already have been experiencing the impacts of climate change. Despite all the scientific evidence, several IPCC, the Intergovernmental Panel on Climate Change, and also governmental reports, despite all this scientific evidence, we've seen the Canadian government failing in its duty to address the climate crisis. And instead, we've seen the Canadian government going in the wrong direction, even purchasing a pipeline on behalf of all Canadians. So from my point of view, it is not radical from young people or citizens to demand that Canada take action on climate change. It is rather some kind of our obligation to do so. So as you can see, one of the reasons why we decided to launch the climate class action is because by not taking significant action on climate change, Canada is preventing us and a whole generation and generations to come to actually have their most basic human rights being respected. Our GHG target is actually an increase in our emissions based on 1990 levels. And we do not even have an action plan that would allow us to reach that already inadequate target. So for those reasons, we can argue that Canada is violating our human rights. And as Jasminka said, we can see several rights, both based on the Canadian Charter, but also the Quebec Charter, that is a little bit more specific about the right to an environment in which biodiversity is preserved. This is also why we believe that we do have a strong case to make our human rights being respected because of this specificity of the Quebec Charter. And so only a few months after meeting with Laure Varidel and her spouse, Bruce Johnston, we decided to launch the climate class action. Actually, it was about 6 months between the early beginning of just this idea of launching the case from my part, and then 6 months later, we were launching the case on the morning of November 18. So you'll see in this timeline that since then, things have been going a little bit slower than what we were hoping for. You can see that in June 2019, Environnement Jeunesse presented the case to the Superior Court of Quebec. The government of Canada obviously also delivered its position against our class action. And then 1 month later, we got the decision from the Superior Court of Quebec, which left us a bit perplexed, basically because Justice Morrison recognizes that climate change represents a threat to human rights, but that is also a justiciable issue, as Jasminka raised a little bit earlier. But the point that was significant for his decision was that we could not identify enough precisely what a young people was. And so in his decision, he said, why choosing the age of 35 years old and under, and why not 20, 30 years old, or even 40 years old? And so to this question, it goes without saying that young people cannot be 50 or 60 years old, for example, and it is quite clear in youth policy from both the Quebec and the Canadian governments that the usual age limit is either 30 or 35 years old. So for us, it was quite clear at this point that we still won on the part of the justiciability, which was for us something that was probably the most difficult barrier to go over, which is something that we're quite happy to see. And then we'll have a next hearing before the Appeal Court of Quebec. But for now, we don't have a specific date, especially with this pandemic across the world. There has been several delays in our court system. And so finally, I know I went quickly over the most basic information of the case, but I've been asked so many times why launching a class action, why not any other action? And then what I usually respond to that is I truly believe that there are millions of ways to get engaged and to fight the climate crisis. The question is not whether a class action is a better way than another. It is certainly something that is powerful. If you think about our case, we do represent 3.4 million children and young people in Quebec, which makes it the most powerful class action based on the number of people that are being represented against a country. So to conclude, this is certainly a powerful tool and a new tool that both personally and as an organization or as a generation of young people, it is certainly one more step that we are taking to be heard and also respected. And back to you, Jasminka.
Great. Yeah, I wanted to also mention something about the Angers case, which leads me to one of the downsides potentially of a class action over ordinary litigation or test case litigation. And that is the unusual remedy that the plaintiffs in Angers asked for. So they did ask for charter damages, right, along the lines of the Ward case that I described for you earlier. But rather than pay the damages to each class member, that is, each person in Quebec under the age of 35, the plaintiffs asked the court to effectively award the damages cypre. To whom? Well, to government agencies that would actually use the money to have a plan and implement a plan to reduce GHGs. So it's a very unusual remedy, because normally if you ask for a cypre award, it's because you cannot locate the class members, you can't identify them. In this case, you can identify all of the class members. You know, there are census rolls or whatever. You could figure out a way to pay people their individual charter damages. But of course, that wouldn't help the overall objective of the litigation, which is for the government to do something, right, about reducing carbon emissions. And so instead, the remedy is, okay, use that money that the court has awarded to take action. And so it's effectively giving the money, you know, from the government back to the government in the form of a cypre award. So that is highly unusual, and that's one of the risks of the litigation. So in the paper that I wrote about this, you know, you have to wonder whether the judges will agree that that is an appropriate remedy for a court to award. So that's one of the risks of the litigation. When I say litigation risks of the remedy, there are delays inherent in class actions because of this additional step of having a certification hearing. So as you can see from the timeline, over a year has been spent already waiting for a resolution of the question of whether Angers' case could be authorized or certified as a class action. So that's an additional step in this type of litigation that you wouldn't have in other litigation. And so it does take up a lot of time and resources. Class actions are extremely expensive, time-consuming lawsuits. And if you're talking about an organization like l'environnement justice, jeunesse rather, or any other type of climate rights, environmental justice group, you have to think of, do you want to spend all of your resources on one lawsuit to the detriment of other initiatives like lobbying or community organizing? So that's one of the cons. In terms of the pros, so why class actions over other types of litigation? I agree with Catherine that class actions have a unique way of generating a lot of publicity because there are so many people involved, and because there's usually a lot of money involved. You know, journalists like to publish headlines that say a $2 billion lawsuit filed against the government of Canada. So it does attract attention, and that of course is one of the strategies that climate justice activists have, is to draw attention of the public to this very real problem. And so in that way, just launching the litigation, even if it's ultimately not successful, could achieve public awareness, which is obviously an important goal. And ultimately, it's about advancing human rights and climate rights and drawing the public's attention to the connections between climate justice and human rights. And so this type of litigation, because it's really, usually brings a lot of publicity with it, and also very, very accomplished, competent lawyers who tend to litigate these types of cases. It widens the pool of legal talent that environmental and climate justice activists can attract. Like, if you can say that this is going to be a class action, you might widen the pool of legal talent that would be interested in participating. So those are the primary advantages I see to using class actions for climate change litigation. It's not a sure thing. We'll have to wait and see what the Quebec Court of Appeal does. They denied authorization, which is what certification is called in Quebec, on the basis of a very bizarre sort of technical argument. I was very happy to see that Justice Morrison found that the case was justiciable, that it was within the competence of the court to rule on whether the government's activity and inactivity violated charter rights. So that was a big victory. But then the judge denied certification on the basis effectively that it wasn't an identifiable class, or that it was an arbitrarily drawn class to only include people under 35, when the evidence was, I thought, pretty straightforward, that climate change is going to impact younger people more than older people. And there is a government Statistics Canada definition of youth that is objectively determinable, and that the definition is persons under the age of 35. So my fear is that the Quebec Court of Appeal will deliver a Pyrrhic victory, that they'll disagree with Justice Morrison that it wasn't an identifiable class, but then will accept the government's argument on appeal that in fact it wasn't justiciable. So we'll see. Hopefully the Quebec Court of Appeal will disagree with the federal court in the Larose case and find that climate change, as it impacts charter rights and human rights, is within the jurisdiction of a court to adjudicate. So we're happy to take your questions.
Heather, it's over to you. That's an outstanding presentation. I've been typing up notes, both in the questions, but also in the for our legal team for looking at in the future. So Heather, if we can get you to share any questions you'd like to, that'd be great.
Sure. Thanks, Byron. And thanks so much, Jasminka and Catherine. This has been a wonderful presentation. So we've got a whole bunch of different questions for you. The first one that I would like to ask, which could be answered by both of you, but I think is a little bit aimed more at Catherine, would be, how are your clients involved in a class action lawsuit? So especially when you're representing youth and your organization is so focused on youth empowerment and education, I was just wondering if you could speak a little bit more about how, if you get involved in a class action as the kind of client, you might get to participate and be involved.
Mm-hmm. That's a really good question. I think from the start, the team at Trudel Johnson L'Espérance also comprises two young women that are extraordinarily involved in the case. They're both under 35 years old. So they've been working on shaping the legal arguments and the presentation we made to the court. They've also been intervening in the medias to provide more detailed information about the legal aspect of the case. And then other than that, the class action that we launched had presented some complexity in terms that we had to keep it secret until the launch to make sure that no other organization was trying to do the same. Because in a such scenario, the court would have said to us that we had to wait until the other case went on, or maybe to join the other case. And so by making it very low profile, we had to keep it quite limited in terms of other young people getting engaged. Luckily, on our board of administrator and our team members, about 80% of the people involved are age 35 and under. So we still have people over 35 years old on our board, but I think they might be 2 people. So the whole decision-making process was led by young people, which was quite important for me. It was also important to have a meeting discussing the strategy. Even if we were not legally experts, we need to understand the implications and not only be used to be the public face of the lawsuit, which was also very important. And then that's pretty much it. I must also say that the law firm is getting involved pro bono, so for free. We do not have to be worried about the expenses that are quite high of a class action. So that was also extremely important for us to be able to benefit from this legal expertise from the law firm.
Thanks. Jasminka, did you have anything you wanted to add? No? Okay. So we've had a number of questions looking at the kind of legal arguments that are made in class action. So I'm going to try and combine some of them and put them in one question so you can both think about it and then give me an answer. So apart from kind of the charter arguments that you've already spoken about, we've had questions about the potential application of the right to equity as a trigger in terms of climate class action. So in this case, the question was about, for example, in the context of women and people with disabilities, the connection between climate change and access to equality. Then Byron asked a great question about making legal arguments framed in the context of treaty and Aboriginal rights, arguing that the exercise of these rights will be impaired by climate change. And then I personally would love to know your thoughts on kind of statutory environmental rights, and if there was more recognition of environmental rights in Canada, if that might make it a bit easier to pursue this type of litigation. So I guess the general question then is, do you see other types of legal arguments being able to be used in this kind of class action climate change litigation context?
I can take a stab at it first. I don't know if I'll be able to answer all of those questions satisfactorily, but let me make an attempt. So on the equality question, that's exactly what is being sought. The Section 15 Charter argument is an equality-based argument that some people are more likely to be harmed by climate change than others. And so young people, so that it's an equality argument on the basis of age. Young people will suffer from the government's actions and inactions more than people in their 70s. But there are other equality-based grounds. So you could easily I don't know that this argument has been made, but you could say on the basis of a disability that some people will be more harmed than others. But to tie into the question about Indigenous rights, the equality argument and the reason why in La Rose, the case on behalf of the 15 youth, they were 15 people who were selected very precisely. It was quite a strategy, and it's a strategy that was used in the unsuccessful Juliana case in the United States. They picked 15 people, all of whom were youth, and so had that equality argument to make, but they also had very specific types of harm. And so people who have breathing problems, who are particularly impacted by not having clean air and suffer as a result, they were included among the 15 youth. They also had Indigenous youth in that group of 15. Why? Because of the argument that Indigenous claimants have particularly strong Section 7 and 15 arguments given their unique relationships to the land and their location in areas of the country that are especially vulnerable to climate changes. Think of the far north, for example. So we have equality-based arguments as well as Section 7 life and liberty arguments framed according to the particular contexts of Indigenous people, people with particular, respiratory illnesses, and so on. So I hope that answers the question. Specifically, whether you would make it on the basis of a treaty violation. If I'm not mistaken, the third action that I listed on the slide on behalf of the two houses of Wet'suwet'en, that's, I think, framed on the basis of Aboriginal law, so treaty rights. But that is a different type of litigation than the one that Catherine is involved with.
Yeah, I don't have much to add except that Raven Trust is one of the organizations that is leading a legal action basically against the tar sands that is violating Aboriginal Indigenous territories. I put the link in the chat.
Thank you very much. Yes, it's a very complicated question, so I appreciate your attempt to answer it. So would either of you have recommendations for organizations or individuals that are interested in initiating a class action? Like what might their first step might be? And this might also combine a little bit with a question for Catherine, which is, would you do it again? So would you launch a class action again? And if so, kind of why? So that maybe you can kind of combine both answers, but tips for anyone interested, Byron and I both are, so at least we'll be taking notes, but any insights would be really appreciated.
Mm-hmm. The quick answer is yes, I would do it again. I think as Jasminka mentioned, there are quite important issues to think of. Is the organization and the people, will they be able to handle the media attention, the public attention in general? Is the legal action led pro bono, or do you need to build an organization and fundraise a lot, which is something that you can struggle with, especially if we think about legal actions that can take a decade to lead. So that's quite important to have a strong organization. As I mentioned, Environnement Jeunesse existed for 40 years now, so we already had a base and a structure in which the legal action could in which we kind of had a support. We had not to struggle with building a new organization to do so, which can be quite challenging, especially if you're not paid to do so. Something else is, I think there are so many opportunities, but you also need to be able to handle all the opportunities that will come to you. And if we think specifically about young people, it can be a huge burden to be someone that is a little bit eco-anxious and has to be presenting the case several times without necessarily having some kind of support. So that's something I also want to be careful with, especially when we think of other countries. We're quite lucky in Canada to not be facing the threat of someone attempting to our lives, which is not the case if we think of several countries in Latin America or in the Philippines or Russia, for example. So that's something that comes to my mind. But otherwise, I think we've got the chance to speak about the climate crisis from a new perspective, from the human rights lens, and that's quite powerful, both in terms of educating the public in general, but also in terms of reaching new publics that were not necessarily aware of the impacts on our personal lives of climate change. When we speak about GHG emissions, not much people will pay attention, but if we think about the impacts on our lives currently and in the future, it might reach more people, and that might lead to a better transition or a faster transition toward a low carbon economy, for example.
Yeah, I would only add, and as far as the tips go, that it would be important for people to pick a jurisdiction in Canada that doesn't have the two-way costs rule throughout. So don't pick Ontario. Stick with Manitoba or BC or the federal court. The federal court also has jurisdiction in this type of case, and they have in the federal court rules provisions for class actions. And in the federal court, they don't have a two-way costs rule. So you would want to insulate yourself from the possibility of having to pay the other side costs if you lose. Now, it also means that if you win, you don't get costs for your legal fees, but chances are the class action lawyers who would take on this case aren't doing it for the money, as we saw with the Johnston Trudel firm. I think that's what it's called in Quebec. This really is, ideological litigation, and you have to have lawyers who are committed to the cause and not just to litigating for the sake of litigating. But there are, I think, increasingly lawyers, ironically from defense firms, that are starting to get involved in class actions on behalf of plaintiffs. So there's a big firm in Toronto that traditionally only represents defendants, that is actually representing a plaintiff in a case in the prairies, it may even be in Manitoba, regarding clean water, the lack of clean water for Indigenous communities. And so here we have very well-resourced, sophisticated lawyers who are obviously doing it not for the money, but for other reasons. Maybe it's the good PR, but what comes with it is that environmental justice organizations have access to lawyers who can afford to take on this litigation and do it well. So, it does have its advantage. Find a good class action lawyer and start your case in a province that doesn't have a two-way costs rule. That would be my advice.
Thank you so much, Yasminka and Katrin and Heather, for the great questions and trying to merge together those questions. And Yasminka, it is in Manitoba that I think they've, McCarthy Tetro LLP has initiated a class action. And it's a really interesting case. So I do want to thank our speakers, just the thought that went into the PowerPoints and then the dialogue. And as a moderator, you're just so well organized and interesting. I got to listen and ask questions. It was pretty exciting. And I know the people listening in, we haven't lost a viewer, and that makes me very pleased. To our participants, there is a survey that will be issued, and we'd ask you to fill it out. And again, I do want to thank our speakers who have been amazing and just so stimulating. This series, we've done our first 3. We're going to take a break for the month of December, but we're going to come back with fire and passion and hopefully be outside of Code Red come January. And the theme will be reconciliation and the environment, which I think will link really well to this subject and also to our first seminar topic, environmental racism. Again, we're really grateful that you've shown such interest in this seminar, and we look forward to hearing from you in January. Thank you very much.